All right. And so I want to now shift and take you back in time to look at what Minister Beatty, the Minister of National Defense, who was the sponsor of Bill C-77, the Emergencies Act, said about the definition in the Emergencies Act when the legislation was introduced. So if I can ask to bring up POE.CCF 603. And just for context, this is a speech that Minister Beatty gave to the House of Commons debates during when Bill C-77 was debated. And specifically, I'd like to go to page 5, please. Perfect. So I just want to take you to the highlighted portion. Perhaps if we can make it bigger so that Minister Lametti can see it.
I'd prefer it smaller so that I can see the context, please.
So just want to take you to
fine the way it is.
So the highlighted portion where it says likewise, what Minister Beatty says is likewise, it has been said that probably the most contentious clause in this bill is the one that deals with public order emergencies. This is a type of situation which gave rise to the use of the War Measures Act in 1970. This clause takes its definition of threat from the Canadian Security and Intelligence Services Act. This fact alone should make us very cautious because of the difficulties already encountered with CSIS in determining what is subversion and what is legitimate dissent. That was one view of the legislation. He goes on to say, I would remind members of this House that the definition of threats to the security of Canada received exhaustive scrutiny by Parliament in 1983 during deliberations on the CSIS Act. The language in this definition has therefore already received Parliament's blessing. So I pause here to note that what Minister Beatty is saying is, we are specifically incorporating the definition that's found in the CSIS Act because this is a definition that Parliament has already blessed. Is that fair?
Commissioner, again, going to Hansard's is something that is frequently done in the course of legal argument to interpret a statute. It's my submission this is not a matter of fact evidence. This is a matter of argument which will be done at the end of the case, and it's not a proper line of questioning for this witness.
So I would say in response that, this is something that I'm asking Minister Lametti to explain about how, he's offered an explanation for why there's a different interpretation under the Emergencies Act because the purpose for that definition is different, or determining the purpose is different. And what I say is, well, I'd like to look to see what was described as the purpose under the Emergencies Act and why they use that particular definition. So I would say that it is an appropriate line of questioning.
I think it's appropriate to ask him what the purpose of the CSIS Act is, if that's what you're doing, as I understand it. And I'm not sure that requires anything beyond his understanding. I mean, if it's a legal interpretation of what the CSIS Act means, that's different. So what is it you're trying to get at from him?
So what I'd like to do is I would like to go through Hansard and have him confirm what the understanding was in terms of what Hansard said about why they used the CSIS Act definition and incorporated it into the Emergencies Act.
Yeah, I'm not sure he can interpret any more than read the words, but I think that's the best you can get from him.
Well, the point that I was going to make, Commissioner Rouleau, was in the very next paragraph, which was the CSIS definition is embedded in the Emergencies Act and it must be read in conjunction. And that changes the scope, and the decision maker has changed, and that's all really I'm comfortable saying.
And sorry, Justice Rouleau or Commissioner Rouleau, Minister Lametti has referred to a following passage in the highlighted portion. And if I could, I just want to go to the next passage so I can ask him a couple of questions about it, because he's now commented on that.
Sure, go ahead. Let's see where it goes.
Thank you. So Minister Lametti, you referred to the fact that must be read in conjunction with the definition of national emergencies. So when you move to the next page, to page 6, What the entire paragraph says is, I would also remind the House that the definition at the head of each of the four major parts of this bill, including the definition of threats to the security of Canada, do not stand alone. They must be read in conjunction with the definition of a national emergency in the preamble of the bill and in conjunction with other restricting provisions. In other words, before the government can declare a public order emergency under Part 2, the emergency situation must correspond to the definition of a national emergency as stated in the preamble. They go on to say, I am told that this double test, as it is called, will be used by the courts to assess the government's compliance with the deliberate constraints and safeguards that have been built into the definitions of this bill. So what I'm saying, Minister Beatty is saying here is that you have to, one, meet the threats to the security of Canada. That's the first part, but also meet the definition of a national emergency under the preamble. That's what he's referring to as this double test.
That's certainly your point of view.
All right. And is it fair to say that they're not saying here that the interpretation of threats to the security of Canada changes because you're looking at it through the lens of a national emergency? They're talking about this two-part test, a double test.
Again, Mr. Commissioner, my friend's question is calling upon the witness to interpret what we see in the Hansard. The Hansard is what it is, and beyond that, we're getting into legal argument on the interpretation of the legislation.
So I'm afraid you're also out of time, so you're going to have to wrap up, and I think you've probably gone about as far as you can with interpreting Hansard.
Okay. Those are all my questions on that. Thank you very much.
During national emergencies to amend other acts and consequence thereof be now read a second time and referred to a legislative committee.
The time surely has come now where we in this House must keep faith with the people of Canada. Bill C-77, the Emergencies Act, will replace the old War Measures Act. It includes safeguarded and appropriately limited powers to deal with 4 types of national emergencies. It ensures that the exceptional powers granted by Parliament will be no more than are needed for the specific emergency at hand. It will ensure a graduated response and not an overwhelming one. In addition, the Emergencies Act will provide for compensation in the event of personal loss, injury, or damage. Mr. Speaker, the bill's preamble defines a national emergency as an urgent and critical situation of a temporary nature that imperils the well-being of Canada as a whole, or that is of such proportions or nature as to exceed the capacity or authority of a province to deal with it, and thus can be effectively dealt with only by Parliament in the exercise of the powers conferred on it by the Constitution. Mr. Speaker, as for the notion that a legitimate protest against the emergency declaration could be suppressed and no one would find out, or that the government could censor the media or simply forbid travel to the troubled area, and that it would be difficult for anyone to find out if the declaration of emergency were justified if no one was allowed in or out of the area, I reply that there's no mention of censorship at all in this bill, in this section at all, and that in fact censorship would be possible only during a war emergency in Part 4.